Hi there. We're going to talk about day 9 of the Sunny Balwani trial. We're going to talk about ethics. We're going to talk about why Mark Pandori left Theranos. And we're going to talk about a motion to strike, Brady material. So hang in there. I'm going to cover it all as much as I can. It is Friday, after all. So who am I? I'm Michelle Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. And as you know, Sunny Balwani was charged with the same 12 counts that Elizabeth Holmes was, and the 6 counts relating to defrauding investors, and then 4 counts relating to defrauding patients, and 2 counts of a conspiracy, conspiring with Elizabeth Holmes to defraud investors and defraud patients. Elizabeth Holmes was convicted in January of 2022 of 4 counts of wire fraud, 3 relating to defrauding individual investors, and 1 relating to conspiring with Balwani to defraud investors. Okay, so Mark Pandori, just in case you popped onto this channel. Oh, let me start first by saying thank you to all of you who have subscribed. I really appreciate you supporting my work. I love your questions and your comments, so please do leave a comment or a question. If you haven't subscribed, please do subscribe and hit the like button, the bell notification, share the videos, and you know the rest. All right, so if you just popped on this channel, Mark Pandori was a former lab director at Theranos. And he was there from December 2013 to May 2014. So what is that? Approximately 6 months. And he said one of the reasons he left Theranos was the resistance he received from Balwani and other higher-ups after he ran proficiency testing on the company's Edison blood analyzers. He said that he had suggested to Balwani and others that they do additional research and development, and that the Edison not be used on patients until the problems with inconsistent blood tests could be worked out. Oh, and by the way, this video is for educational information purposes only, and it's simply my opinion. But I do want to hear your analysis. Okay, and he said that when he told Balwani about this, Balwani was upset and angry and told Mark Pandori that would never happen. In other words, relating to doing additional research and development on the Edison, I assume. And then when he was asked by the prosecution whether Pandori considered elevating his concerns to the company's CEO, Elizabeth Holmes, Pandori said he didn't expect that would result in a different outcome. He didn't expect, if he had raised his concerns with Elizabeth Holmes, that it would have resulted in a different outcome. He said, quote, "I considered Mr. Balwani and Elizabeth to be unified in all of their decision-making processes." So again, this goes to, I'm sure the prosecution's asking these questions and eliciting this testimony because the defense in Balwani's case is trying to distance him from Holmes, right? Say Holmes is the one who made the call. Holmes is the one that everybody, took direction from, not Balwani, right? So shifting the blame to Holmes. And then Pandori said they seemed to get along really well with each other. That Elizabeth and Sunny got along really well with each other. And then when he was asked about the company's purported revolutionary Edison machine, the blood analyzing machine, Pandori responded, "I did not find it groundbreaking." And in addition, here's the ethics part. In addition, Pandori said his ethics were challenged at Theranos because product managers and higher-ups put, quote, "a higher level of pressure," unquote, on the lab to get rapid results back for blood samples collected from potential investors. Do you remember the prior video I did where Pandori, those list of emails that I showed you in that video, I think one of them was dealing with Mark Pandori's question about what was going on with Brian Grossman's blood sample. And Brian Grossman, if you remember, was the witness who testified in the Holmes case, investor witness, representing the PFM Health Sciences Fund in San Francisco that invested $38 million into Theranos. So Brian Grossman, I assume, as part of his due diligence, went and checked out and got a blood sample done on the revolutionary Theranos analyzer. And in the email, in yesterday's video, I think it was, or 2 days ago, the prior video, you will see that he was asking questions about what was going on with Brian Grossman's sample because they were having problems testing it. They were having results failing and it wasn't working out. Okay, so he said, his ethics were challenged because he was put a higher level of pressure on the lab to get rapid results back for blood samples collected from potential investors. Quote, they would be put in front of the line, Pandori said. It sort of misrepresents the efficiency. It wouldn't accurately reflect the turnaround time. In other words, if they're taking, these investors' blood samples and putting them to the front of the line, that's not representing to everyone else, or that contradicts the representation that they're giving fast tests to other people. So kind of interesting that was brought up. So then what did the defense do? Some of the highlights of the defense is that they, they're again trying to show that, Elizabeth Holmes started the company. Elizabeth Holmes was in control. Balwani just worked there. He was the COO, right? And that Holmes had developed the relationships with the pharmaceutical companies and with the investors prior to when Balwani ever got involved in the startup. So that's kind of interesting because I think Balwani joined in 2009. And if you look at the indictment video where I walked you through the indictment of the charges against Balwani, you will see that counts, I think it's 3 through 9. If you look at the dates of when those frauds were alleged, the wire fraud, the money that they were getting from the investors, I think that was late 2014 to 2015. So Balwani had already been working there, what's 2009? How many years that is? What is that, 5-6 years? So I don't know about that argument. But anyway, again, just my opinion, and I don't, who knows why they're suggesting that at this point. I don't know. Let's see what happens. Then today, and I'll get to the motion to strike and the Brady material in a second. Then today, there again, Mark Pandori was on the witness stand, continued his testimony. And today being day 9, Friday, April Fool's, he was again on the stand, Pandori was on the stand, and the defense was trying to point out that Balwani was basically following the direction of Elizabeth Holmes, right? She was the leader, he was the follower, and also that they said they started referring to Balwani as a shareholder. So again, using language to further distance him from the role of COO and to distance him from what Elizabeth Holmes was doing, right? They're trying to distance him. So we'll see. We'll see how that pans out. They have many other witnesses to question, and we'll see what happens. And the prosecution today also showed several emails from Balwani to Theranos executives and other employees about the company's blood testing devices, trying to establish that he was making executive decisions. So we have the prosecution trying to paint the picture to the jury that no, Balwani wasn't over here. He wasn't just taking directions from Elizabeth Holmes. He was actually making executive decisions as a COO would, right? But again, that's the theory that the prosecution is pursuing. And in the defense, is trying to counter that. It's not executive decisions. He walked into a company that was already established, relationships that were already established. He was just doing his job, basically. He was, I guess, a shareholder. He was a shareholder or someone who wasn't, if you look at the video I did, the prior video, you'll see an email where concerns were raised to Balwani regarding they were having problems with the testing results. Erica Chung was letting Adam Rosendorf know, and then that went to Mark Pandori, and then went to Balwani, and then Elizabeth Holmes stepped in, right? So if you go look at that video, prior video, you can see the email. So, maybe that goes to show, that the defense's theory supports the defense's theory that, Balwani was just taking direction. He wasn't the leader. He wasn't the one making the call. Elizabeth Holmes was. Okay? So, now let's switch gears here. Apparently on Tuesday, there was a court hearing, but it was sealed. In other words, closed. So it was just between counsel and the parties and the judge. And it was relating to a Brady. It was a Brady hearing. And what's Brady? Brady is a Supreme Court case. It's called Brady versus Maryland, if I remember right. It's a case that set the precedent that requires prosecutors to turn over any exculpatory evidence to the defense. What's exculpatory evidence? Any evidence that's favorable to the defendant. So that could be impeachment evidence regarding witnesses. It could be evidence relating to the credibility of witnesses. It could be any favorable evidence relating to the defendant. So I don't know what happened because it was a closed hearing, but when Brady comes up, that tends to indicate that the prosecution, the defense is alleging, the prosecution did not turn over evidence that was favorable to their client, to Balwani, or maybe impeachment evidence or relating to one of the witnesses. I don't know what happened because it was closed. It was a closed hearing. But there was a motion to strike this morning before the trial started this morning. Now, a motion to strike, to me, if I connect the dots, if there's a problem with Brady material, if the prosecution didn't turn over the discovery timely, then one of the remedies could be the judge could say, okay, prosecutor, you can't bring that evidence in. Or any of the evidence that has already been admitted, I'm going to strike it, right? Could be witness testimony. It could be exhibits that were entered. I don't know, okay? I don't know what happened with the motion to strike, but maybe I'll find out. But the case did proceed. Pandori did testify. So that's pretty interesting development, though. All right, now I want to do just a couple minutes of shout out to all you subscribers. And I thought I would go over a few of your comments or questions because I think it would be helpful to all of us. So one of the questions I got is regarding, and it's a shout out to Prickly Pear. Thank you for subscribing. He or she asked, can answers to civil interrogatories, now this is relating to the Laundrie case regarding Gabby Petito being killed by Brian Laundrie and Gabby's parents suing Brian's parents for emotional distress. You can go ahead and take a look at those videos that I've done. Anyway, so he or she asked, Prickly Pear asked, whether answers to civil interrogatories can facilitate a criminal case. Yes, they could. And I can give you an example in the Cosby case. In the deposition that Cosby gave resulted in, I think, the criminal prosecution of Bill Cosby. But here's the deal. Civil interrogatories are questions, written questions that are sent between the parties. So say they're sent to the Laundries to answer these questions, right? What happened? What did you know about Brian? Did he ever tell you? Blah, 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 and they fill it out. Well, I can tell you this, that most of the time those questions will be objected to, and I'll tell you why. One of the reasons why it might be constitutional Fifth Amendment right to remain silent, because maybe the Laundries will assert that maybe they're under investigation or possibly could be investigated or charged with a crime, accessory after the fact. I don't know. But, Interrogatories don't always mean, just because you send questions to the other side doesn't mean they're going to give you answers. All right. So thank you for that question. All right. So Sarjan, I don't know if I'm saying this right. I'm probably not. Bozen, thank you also to subscribing, and he or she suggested that I start using thumbnails. Okay, I didn't go to art school. I went to law school. So I'm trying, and I did do some thumbnails. So please let me know what you think about those thumbnails. I can take it, don't worry. All right, then Adorable Girl, thank you also to subscribing. Asked whether, she gave a great, she or he, I guess it's a she, Adorable Girl. She gave a great explanation, and I put it in the comments section. She gave a great explanation of coefficient variation. You guys should go read it, because in the prior video, when I showed you the email where they were only getting 33% results, in her explanation, she explained what that really means. I guess it means that the rest of the time they were getting it wrong. So their blood results, I don't know. Go ahead and look at it. So thank you to Adorable Girl for subscribing. And Chris Cripps, this is second to the last one, also had a question, and thank you to subscribing too. Asked whether, or made a comment saying the laundries aren't out of the woods because they could be charged with accessory after the fact, right? Brian committed the murder. He comes home to Florida to his parents' house. They retain a lawyer. Did they know some stuff? They didn't tell the Gabby's parents where she was, i.e. the result of, that's the basis of this lawsuit. So if you look at my video that I did on whether or not the laundries could be charged with anything, you might want to take a look at that, because I kind of go through a couple sections of the Florida law. I'm not a Florida lawyer, I'm a California lawyer, but I thought it would be educational to look at that. And one of the things about the sticky point with the accessory after the fact, in my opinion, all right, is that it's the words that say with the intent to help the offender, that would be Brian, avoid or escape detection or arrest or trial. So how do you show that the laundries had the intent to help Brian avoid or escape detection? If, as has been reported and has been stated by the laundry's lawyer, that their right to remain silent, they have a constitutional right to remain silent, right? As horrible as the circumstances were and are, how are you going to be able to show that they had any intent? Maybe there's actions that they took could show intention. I don't know. We're going to have to find out, but that was a great question. So thank you for that. Last subscriber question. This comes from Blair, and asked whether I think that the laundries would claim privilege to every question that the Gabby's parents ask. And we're going to see it. And as I said earlier, maybe the constitutional right to remain silent, asserting the Fifth Amendment. That might be their answers to these interrogatories. We're going to find out, right? So, and he or she also commented that there's no privilege between parent and adult parent in Florida, which I kind of thought maybe that was a joke, but yeah, there isn't. Okay. Maybe in some states there is between parent and child, but parent and adult parent, meaning the laundries and their son Brian, who was, I think, 20, he was in his 20s at the time, so an adult. Is there a privilege? Not that I'm aware of, but that was an interesting question. So thank you, Blair, also for the question and for subscribing. Okay, so that's it. That's the highlights for today. So thank you very much for watching. And please do subscribe. Please support my work. And leave a comment or a question. And hit that like button. Hit the bell notification. And do subscribe. Thank you.